Is Mr. Stevens? Mr. Stevens is here. Mr. Stevens?
Yes, Judge.
Okay. My understanding is that there's a new file that Mr. Hayes needs to be arraigned on.
Correct.
Let's see if we can find it. This is a this is actually a felony. He's got to come in for a felony arraignment.
I suspected that might have been the case.
Is there
How do you want to handle that?
Your Honor, I can.
Are we trying to run it in tandem with the other file? He does have a preliminary examination next week. Well, let me call the case. On the record in the matter of the people of the state of Michigan versus Valerie Hayes, file number is 23-02495 FY, counsel appearance.
Andrew Stevens on behalf of the people.
Thank you and good morning or good afternoon, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Valerie Hayes.
Okay. And then we also have here file number 23-02554 FY, which it looks like was recently issued and signed on the 14th of August. He would need to be in person to be arraigned on that because there's 3 counts of felony controlled substance manufactured delivery and an habitual offender fourth offense notice attached to that. So is he able to come in at all today, or how do you want to handle that?
Your Honor, I'm not sure whether he's able to come in today at all. We were just Mr. Stevens was gracious enough to just make me aware of this file this morning. Our intent was to try to have Mr. Hayes arraigned on this new file today. And then we were going to waive, or we're prepared to waive the timeline for the preliminary examination in this matter. From what I understand, and based on my conversations with Mr. Stevens, these are essentially related files. The plan for all of the parties was to adjourn the preliminary examination in this matter, currently scheduled for next week, so that we could run the preliminary examinations in both matters at the same time. I believe, and Mr. Stevens can certainly correct me if I'm wrong here, but I believe that this will be mostly the same witnesses involved in both files.
Mr. Stevens?
That's all accurate, Judge.
Okay, so what we could do is we could either continue to the preliminary examination date, treat it as another probable cause conference. He can appear in person and we can arraign him on the new file if he wants to wait that long with the warrant pending. Anything can happen within a week, or he can arrange to be arraigned this weekend on the new file.
I'll defer to Mr. Palmer on that one.
Your Honor, I think I would need to speak with Mr. Hayes just very quickly because I wasn't aware that we couldn't get him arraigned. We were anticipating him being arraigned today on Zoom, so I would need to speak to him as to what he intends to do.
I mean, we can certainly just agree to waive the timeline on the first one, and then the two of you could figure out how you want to proceed on the second one.
That would be fine, Your Honor. We could certainly set the matter out a couple of weeks on for the preliminary examination on the file that's currently pending before the court, and then I can privately meet with Mr. Hayes to address how to get him arraigned on the new file. And then hopefully if we set the prelim out a couple of weeks, hopefully that would allow him to have time to get that arraignment taken care of and the second case back on track.
Okay, so he definitely has to turn himself in because it's a fresh warrant, so he's got to be advised of that. And so we're not allowed to arraign him on a fresh felony warrant via Zoom. But nonetheless, as it relates to the file that's pending for exam next week, Mr. Hayes, do you understand that you have the right to have your preliminary examination within 21 days of your arraignment?
Yes, ma'am.
Okay, and due to the fact that you have a new case pending, and you would like to run both of these examinations at the same time, are you willing to waive the timeline so that I can reset it for a new date?
Yes.
Okay, let me get your new date.
It'll be October 5th at 10.
October 5th at 10 a.m.
Okay.
That time work for you, Mr. Stevens and Mr. Palmer?
Should be fine, Judge. Thank you.
October
thank you.
October 10th. Is that what?
5th,
Oh, 5th.
5,
Got it.
correct, at 10 a.m.
Understood. That works fine for me, Judge.
Wonderful. Do you have any questions today, Mr. Hayes?
No, ma'am.
Any additional matters for the record, counsel?
Nothing from the people. Thank you, Judge. Thank you, Mr.
No.
Palmer.
I have nothing from the defense, Your Honor, although now that we're done with the record, if I could have a breakout room with Mr. Hayes very quickly.
Very good. I'll put you in room 2. He's doing what, a waiver? Mr. Abbott, what are we doing with Mr. Linton?
Linton, Your Honor, is in custody. We'll be waiving the 21-day rule, please.
Okay,
Asking for an adjournment.
okay,
There's
give
some
me,
negotiation to be done with the House.
sounds good. And Ms. Donnelly, what are we doing with Porter?
I want to leave that on for next week to address the timeline when needed. I've spoken with Ms. Porter and I want to follow up with her CMH and healthcare providers. We do have an offer though for the record.
Okay, on the record in the matter of the people of the state of Michigan versus Betty Porter, file number 23-02333, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Betty Porter, who is present and standing to my right.
How are you, Mr. Porter?
Good.
Okay, today was the date set for probable cause conference. The matter is scheduled for preliminary examination, 9:30 in the morning, August 25th. And you want to continue or to keep that date at this time and place an offer on the record?
Yes, Your Honor. The parties would like this just left on for preliminary examination. The people would like to put on the record that we have extended an offer for the defendant to plead to an added count 2 of use. With that, the people would dismiss count 1.
That's complete and accurate?
Yes, Your Honor.
Okay, and so you want to continue to examine and mention something about her CMH?
I'm going to be following up with her healthcare providers. And I believe that Mr. Brodowitz wanted to also follow up on some of the discovery as well.
Yes, that's correct.
So we don't know if we're gonna, my intention is not to run a preliminary exam next week, but we don't want to need to address the timeline now.
Okay. Do you have any questions today, ma'am? I don't know.
No.
Okay, so we'll continue to the next court date and address the timeline as necessary. Bond was set at 1,000. Personal recognizance that will continue. Any additional matters for today's record?
Nothing from the people, Your Honor.
And nothing for defense. Thank you.
Okay, you're all set for today, ma'am. We'll see you next week. Okay, do I have an assistant attorney general? No, I think I do. Who's in the jail?
Mr.
That was in the waiting room? I don't see anyone in the breakout room anymore. Is Mr. DePriest no longer on it? Need to call the jail. Mr. Neal, I don't see There's no one in the breakout room though. Oh, okay. Mr. Neal, were you all set in room 4 with Mr. DePriest?
Yes, we're all set, Your Honor.
Oh, who's the prosecutor on that matter?
Is that
Sarah
Teresa
Paula.
Morel? Yeah.
Oh, she is there, okay. Well, on the record, as soon as he gets here. Is he here? You can close the breakout room. Okay, sorry, it's taking another 23 seconds to close the breakout room.
No worries, Your Honor.
Okay, Mr. Morel, can you hear me?
Yes, ma'am.
Okay, we're on the record in the matter of the people of the state of Michigan versus DePriest Deshaun Morel. This is file number 23-02444 FY, council appearances.
Thank you, Sarah. Pulled on behalf of the people.
Good afternoon, Your Honor. Rico Neal, the print on behalf of Mr. DePriest Morel, who is present via the video system, do consent to the proceedings in this form and fashion.
Thank you. Today was the date and the time set for a probable cause conference. The matter is scheduled currently for preliminary examination on August 25th at 8:30 in the morning on one count of homicide, open murder, and count 2 weapons, felony, firearm. Are we continuing to examination at that time, or do we need to address any timeline issues?
Thank you, Your Honor. I have consulted with defense attorney on this matter. I understand he was recently retained. In discussions with him, I believe defense will be requesting an adjournment. I have been in touch with your office regarding dates, and I believe that we've found a date that works for both parties, and that being September 29th at 10 a.m.
Yeah, that's correct and accurate statement made by counsel. I do believe that the 21 days have previously been waived by my client. I have discussed that with my client. He's in agreement as well. If the 21 days have not previously been waived, he is prepared to waive the 21 days.
Okay, yep, it does not appear that it's been waived. He was arraigned on August 5th. So it would have been exactly 21 days on the 25th, or 20 days, that is. Nonetheless, Mr. Morel, you have the right to have your preliminary examination within 21 days of the date of your arraignment. And because you recently retained counsel and you need to get discovery and review that discovery in preparation for your defense, are you willing to waive the timeline so this matter can be reset?
Yes, ma'am.
Okay, so we will get you that, you said it was September 29th? At what time? This matter will continue to exam September 29th at 10 a.m.
Thank you.
No problem. Any additional matters we need to address while we're on the record?
Not from the people, Your Honor.
Your Honor, as it relates to my client in regards to bond, I don't believe there's been a bond that was previously set on this matter. If we may address the issue of bond.
You can address the bond at this time.
Thank you, Your Honor. Your Honor, 17-year-old residents of the community has no prior record whatsoever. I understand the severity and the nature of these pending charges. He would return to reside with his mother, either in Flint or they do have a property, I've been told, in Okemos, Michigan. Therefore, he is not a flight risk. Again, understand that the severity of these charges may cause some concern to the court. He was currently going to be a senior at Okemos High School, with school starting relatively soon, I believe this week or next week, we'd ask the court to consider granting him a reasonable bond in which he could potentially post. We're not opposed, if this court is inclined to grant him a bond, we're not opposed to a GPS tether with the lockdown so that he can prepare to attempt to attend some schooling during the pendency of this case.
Did the prosecutor want to respond to the motion?
Thank you, Your Honor. If the court is inclined in setting a bond in this matter, I would ask that it be no less than $100,000 bond. We do have a case where this defendant was in possession of weapons and used the weapon against another in killing that person and also injuring another person who is a witness in our case. I've spoken with the victim's family and they are concerned with their safety if the defendant is released. I'm not familiar with what the defendant's history is. I do know that there is gang activity in the family. The defendant's brother, Keaton Morrell, is currently in prison for armed robberies he committed while part of the 21K gang. Not necessarily sure that the defendant is currently involved in gang activity, but my concern is that there may be a history of violence in the family because of the history with his brother, the gun activity with this specific defendant leading up to the open murder charges that he faces here. So based on my concern with community safety, the severity of the charges, I would ask that Your Honor set a bond no less than $100,000 cash assurity.
The defendant was arraigned on August 5th by, I believe, Judge Ward. At the time, Judge Ward would have had far more information before her than I did to make a determination as to how to set the bond. She would have at least had his criminal history, which I don't even have before me. All I have is this file, which doesn't include any of that information. She specifically indicated in the note, however, that he was remanded pending pretrial services investigation report, which I don't believe we received because there's no copy in this file. And so I do not feel comfortable amending or setting a bond at this time because we still haven't received, or I haven't received what I need to receive to make a careful consideration of any posed or potential threats to the public safety other than what's before me as it relates to the allegations charged in this particular file. And so at this time, bond is going to be denied pursuant to MCR 6.106B1, and he'll remain remanded until the time that we receive a pretrial services investigation report with further information.
Thank you, Your
Any
Honor.
additional matters?
Nothing further from the defense. We just ask that there be an expedited process for the pretrial service report if the court would do so.
I will note that, and I'll see if we can get that expedited. And then once that happens, we can set it for a hearing sooner than later if necessary.
Thank you very much.
Any additional matters at this time?
No, thank you.
Nothing
Okay, you're
further.
all set for today. Thank you. You're all set for today, Mr. Morrell. Okay, let's see if pretrial services has that report and maybe failed to provide it. I'm not sure. Okay, I'm not sure who this is in the waiting room. Johnson's an attorney, and then Annette to air. On the record in the matter of the people of the state of Michigan versus Marion Ellen Sheridan, file number 23-02222FY, counsel appearance.
Good afternoon, LaDonna Logan on behalf of the people.
Good afternoon, Your Honor, to you and your staff. My name is John Freeman, and I'm retained counsel for Marion Sheridan. Can you hear me?
I can hear you. I'm waiting for the Assistant Attorney General to start our video.
Your Honor, I'm in a moving vehicle and it's been my experience, if I start the video, it's gonna freeze the feed.
Okay, sounds good. You're not driving though, are you?
I am not driving.
Okay. Today was the date and the time that was set for a probable cause conference. This matter is currently scheduled for preliminary examination on August 25th at, I believe this says 1:30 p.m. One count of conspiracy to commit forgery, count 2 of forgery, count 3 of forgery, count 4 of conspiracy to commit uttering and publishing, count 5 uttering and publishing, count 6 conspiracy to commit election fraud and forgery, count 7 election law forgery, and count 8 election law forgery. Are we continuing to examination on this matter?
Your Honor, if I may be heard on that, first for the record, my client, Marianne Sheridan, appears via Zoom, although her appearance has not been acknowledged by the court on the record. She is on the Zoom screen. And she and I both agreed to be here by way of Zoom. As far as the scheduled exam date, I've been recently retained on this particular matter. I've spoken with Assistant Attorney General Logan, who appears for the people. It's my belief that the people are not going to have an objection to the request that I'm about to make of the court. My request of the court is that this matter be set out for a long adjournment. The reason for that is that this case is anything but typical. There are very significant factual and legal defenses that are going to require an extensive assessment of the very voluminous discovery material that I received earlier this week. I'm going to need to do a deep dive into the facts as well as a deep dive into election law. There may very well be a need for some factual investigation on my part. And as a result of that, Your Honor, I know that some of the other defendants in this matter have exams set as far down the road as November. Between the complexity of the case and my schedule, I'm asking for an exam date in January of 2024, with perhaps a probable cause conference in advance of that. There may be some pre-hearing motions that are going to be warranted. There might be some issues with respect to discovery. I don't know if I have everything or not. I'm just getting my feet wet into the case. And that's my request on behalf of Mrs. Sheridan.
Okay, did the AG stipulate to a date in August? I'm not understanding. I mean, I'm sorry, in January. Why are we going so far out to January?
Your Honor,
Sorry,
my reasons for wanting to go so far out are just laid out for the court. This is an incredibly complex set of facts and circumstances. There are both factual defenses as well as very significant legal defenses, both of which I think hotly contested at the preliminary examination and may very well be hotly contested in motion practice before the hearing itself.
Correct. The matter that I had earlier this morning, I set it out in November in anticipation of some motions being filed, and I'll address the timeline after those motions are filed. But I didn't set it out in January without those motions being filed.
Well, Your Honor, I can't represent to the court at this point exactly what motions I might file. I've only been acquainted with the case since I filed my opinion earlier this week. I've only had the discovery for a couple of days at the most. I do have a very full trial docket myself with other matters, that one of which is scheduled for trial in Oakland County. The case has been pending for almost 2 years. It's a during COVID case that involves multiple allegations of criminal sexual conduct. And that's scheduled to take 2 weeks, and that's scheduled for the end of October into the beginning of November. So I'm trying to accommodate the complexity of this particular file, as well as manage what is a heavy docket for myself. January is wide open.
Okay. Did the Attorney General want to respond?
Your Honor, as far as the exam date, I would leave that to the court. We do have an October 12th date and a November 2nd date for co-defendants, but it's my understanding that both of those dates are not flexible for Mr. Freeman. So I would leave it to the court as far as the exam date.
Okay. Let's see here. What do we have a date in December? And is your client willing to waive the timeline in order to have it set out that far?
Absolutely, Your Honor. I've had an opportunity to discuss that with her, and she is in agreement that a waiver is in her best interest.
Okay, Ms. Sheridan, if you can unmute your device. Okay, Ms. Sheridan, you understand that you have the right to have a preliminary examination in this matter within 21 days of the date of your arraignment?
Yes.
Okay, and due to the reasons stated by your counsel, including the voluminous amount of discovery, the complexity of the matters that he may need to brief, as well as his schedule, are you willing to go beyond the 21-day timeline to have this matter reset?
Yes.
Okay, what I'm going to do at this time, Mr. Freeman, is I'm going to set it for another probable cause conference in December so that we can know how we need to proceed.
Thank you.
Does it have to be in a day or here? It should be. So. For PCC. We don't have, unless I add it on the date. You can add it to PCC. Do December 15th. December 15th work? At 10. At 10 a.m.?
Yes, Your Honor. Is that in person or via Zoom?
The probable cause conference can be held via Zoom.
And that's 10 a.m.?
10 a.m.
Thank you very much.
No
Thank you, Your
problem.
Honor.
Thank you. Okay, and bond was set in this matter at 1,000 personal recognizance. Are there any additional matters that we need to address on this record today?
None for the people. Thank you.
No, Your Honor. Thank you very much.
Thank you. You're all set, Ms. Sheridan.
Mr. Abbott is here.
He's here with who?
Joel Smith and Willie Smith.
Is Sir Terrio Coulter here? Terrio Coulter fair to appear? Bench warrant. Just Kenneth Thompson. On the record in the matter of the people of the state of Michigan versus Joel Smith, file number 23-02307. Appearance for the record.
Jeff Brodowitz on behalf of the people, Your Honor.
Good afternoon, Your Honor. John Abbott with the Public Defender's Office representing Joel Smith. He's standing to my right.
Today's the date and the time that's set for a probable cause conference. This matter is scheduled for preliminary examination next week, August 25th at 8:30 on one count of assault with a dangerous weapon. How are we proceeding?
Yes, Your Honor, at this time of conversation with the defense, I believe we will be leaving this on for preliminary examination. The people have extended an offer for the defendant to plead to an added count 2 of assault and battery. This that would dismiss count 1. However, I believe Mr. Abbott will be out of town, so I believe the defendant will be waiving his 21 days and asking for a reset of the preliminary examination.
Mr. Abbott, are you still planning on going on vacation?
Still planning it. So I'm requesting that the court adjourn our case. I do want to hold a preliminary exam, but I can't do it this Friday, the 25th, or the following Friday.
Okay, did you talk to your client about the timeline?
I did.
Okay, Mr. Smith, you understand that you have the right to have preliminary examination in this matter within 21 days of the date of your arraignment?
Yes, I do.
Okay, and so because your attorney will not be available Are you willing to waive the 21-day timeline so we can reset this?
Yes, I am.
Is he forcing you to do that?
Yes.
He is forcing you?
No, he's not forcing me.
Oh,
He's
okay.
recommended.
Okay, sounds good.
I want him to have a vacation as well.
Do you? You probably earned it. We'll reset it. October 5th at 10. October 5th at 10.
Thank you, Your Honor.
No problem. Bond was set at 1,000 personal recognizance with a no contact order protecting the alleged victim, Tiffany Isham. And you're not to be within 1,500 feet of wherever she lives, works, or goes to school. I don't see where that's been an issue. Bond will continue. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from the defense. Thank you.
Thank you, sir. We'll get you a new notice to appear for your exam, okay?
Thank you. Appreciate your efforts.
No problem. On the record in the matter of the people of the state of Michigan versus Willie Smith, file number 23-02437 FY, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good afternoon, Your Honor. John Abbott representing Willie Smith, who is now stating to my left.
Okay, Mr. Smith, how are you?
How are you doing?
I'm doing well, thank you. Today is the date set for probable cause conference. Your matter is scheduled for preliminary examination, August 25th at 8:30 in the morning. Count 1, controlled substance delivery manufacturer. Count 2, weapons, ammunition, possession by felon, and there's a habitual offender fourth offense notice. Are we continuing to examine on this?
Yes, Your Honor. I believe that the people have not made an offer at this time. I believe this will be left on for preliminary examination. However, again, I believe the defendant will be waiving his 21-day timeline at this time.
Okay, and Mr. Smith, you understand you have the right to have preliminary examination within 21 days of the date that you're arraigned?
Yes, sir.
Okay, and because your attorney is going to be away, are you willing to waive the timeline?
Yes, sir.
Okay, anybody making any threats to you to get you to waive the timeline? Okay.
Will be October 5th at 10.
October 5th at 10:30.
Thank you, Your Honor.
No problem. Do you have any questions today, sir?
No, ma'am.
Okay, bond was set at 5,010%. That will continue. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from the defense. Thank you.
Thank you. You're all set. On the record in the matter of the people of the state of Michigan versus Kent Vanderwood, file number 23-02224 FY, council appearance. Brian Lennon, can you hear me? I don't know if I can't hear them. Is the AG still here?
Yeah.
AH, can you hear me? That's what happens when you're in a moving vehicle. You might not get a signal. Okay, I'll call that case later. Let's see here. On the record in the matter of the people of the state of Michigan versus Stephen Williams, file number 23-00434 and 23-02019. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Stephanie Korndike on behalf of the defendant.
And then Mr. Williams, I see he's present via Zoom. Today's the date and the time that's set for probable cause conference on both files. I have one, a police officer fleeing a third degree, and the other is a assault and a domestic violence. These matters are both scheduled for preliminary examination, August 24th. File number ending in 2019 is scheduled at 10, and file number ending in 434 is scheduled at 10:30. Are we continuing to exam?
Yes, Your Honor, at this time, this will be left on for preliminary exam. The people have not extended an offer at this time. However, between now and the preliminary exam, that may change. I have spoken with Ms. Korndike about this, and I believe we're on the same page.
Ms. Korndike?
Yes, counsel is correct. Your Honor, I believe there's some things that the prosecutor needs to button up before we proceed, but it's my intention to run at this time unless we hear something positive from the prosecutor.
Okay, sounds good. So these matters will continue to examination in person at the court, August 24th at 10 o'clock and 10:30 respectively, and then bond in file number 23-02019, which is 9,000 cash surety, will continue. And then the bond in file number ending in 434, 9,000 cash surety with a no contact order protecting Tara Hopkins will also continue. And the defendant is on GPS tether. Is that correct?
Correct.
Okay, that will also continue. Any additional matters at this time?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor.
Okay, you're all set. Thank you.
Thank you. Have a wonderful day.
Same to you. I'm not sure which file this came off, so this is not really this file. Let's see, it looks like. Okay, AAG Logan, can you hear me?
I can, Your Honor. Can you hear me?
I can hear you. And then Brian Liddon, can you hear me?
I can, Your Honor, and I apologize for the technical glitch here.
Looks like both parties had technical glitches at the same time, so it worked out. Okay.
Thank you, Your Honor.
Back on the record in the matter of the people of the state of Michigan versus Kent Vanderwood. File number is 23-02224, counsel appearance.
Good afternoon, Your Honor.
Good
Brian Lennon and Mike
LaDonna
Bogle.
Logan.
Oh, I apologize. AAG Logan.
Let's go with the prosecutor first, then defense counsel.
Good afternoon, LaDonna Logan on behalf of the people.
Thank you, Your Honor. Brian Lennon and Michael Bolville, Warner Norcross and Judd on behalf of Kent Vanderwood, who's seated next to me.
Very good. Today's the date and the time that's set for probable cause conference. This matter is scheduled for preliminary examination. It's scheduled for August 24th at 1:30. I'm inclined to believe there's going to be addressing of the timeline today. Is that correct?
That is correct, Your Honor. And I heard the court mention that the court already has a preliminary exam extended to November 2nd. That would work for us. I've spoken with Mayor Vanderwood regarding his needing to waive that timeline. He's prepared to do so today, Your Honor.
Okay. Okay, so Mr. Vanderwood, you understand that you have the right to have a preliminary examination in this matter within 21 days of your date of arraignment.
Yes, Your Honor.
Okay, and due to the complexity of the issues at stake here, as well as the amount of discovery that's pending, would you be willing to waive that timeline freely and voluntarily?
Yes, Your Honor.
Okay, so we'll reset this until the November date. November 2nd at 10 a.m. That's in person at the court, okay?
Yes, Your Honor. And if I may I address one condition of bond?
What is that?
Your Honor, I asked the magistrate judge because Mayor Vanderwood travels quite a bit with his responsibilities, both with his private employment and as the mayor of the city of Wyoming. I'd asked the court to consider allowing us to essentially remove the standard condition that requires court pre-approval for travel. And so the magistrate judge imposed, said that we needed to bring that up with you, Your Honor, and asked the court to consider that.
Okay. Did the AG want to respond to that request?
No, Your Honor, I would leave that within the court's discretion.
Okay. I can imagine that there's probably extensive travel and it could become cumbersome. I do have concerns because there are some others that have already expressed their requests for a similar removal of the travel requirement. The concern that I have is the typical nature of these requests that you need to provide a request that indicates the times and dates of travel and where you intend to travel. But because he's the mayor of the city of Wyoming, I think that could become cumbersome for the court and for pretrial services. So in this case, I will remove the travel outside the state for his purposes of his employment.
Thank you, Your Honor.
No problem. Okay, so otherwise bond will continue as set at 1,000 personal recognizance. All other conditions will continue as well. Any additional matters on this record today?
No, Your Honor.
None.
Thank you.
No, Your Honor, thank you.
Thank you. You're all set for today, counsel. Okay. Lincoln's in custody, that's correct. What are we doing with that, then you did? The waiver? Oh, okay.
If I may, I know I can fill the floor in, Mr. Evans.
Okay, I'm gonna, let me see if I can clear some more people out here, because people are coming in this waiting room left and right, I don't even know. I'm gonna need for you to monitor who's admitting people, so I need you to check and see who they are.
Okay.
Haggard.
Oh dear.
Lundgren. Okay, I see who she is. I'm gonna place you on mute until it's time for me to call your case. Okay, on the record in the matter of the people of the state of Michigan versus Victor Nwagbara. Is he present? File number is 23-02457. Council appearance.
Thank you. Sarah Polda on behalf of the people.
Good afternoon, Mayor. Please, this honorable court, Kareem Johnson, on behalf of the defendant, Your Honor.
Okay, where is your client?
Your Honor, we were recently appointed down in Jackson County. The contact information that we have, my office did send a letter out to my client earlier this week, and I've tried to contact him twice. I've been unable to get him via telephone, and I don't know if the letter's made it yet. I do understand that the co-defendant's attorney is asking for an adjournment of the preliminary examination date. I'm humbly asking the court to waive my client's appearance for today and see if he shows up on the preliminary, if I can get him here for the preliminary examination date, not issue a bench warrant.
Okay. Your client was arraigned August 5th. He was handed a copy of his court date. That date did not change. So he knew to be here. It's all supposed to be on GPS tether with victim notification. He's failed to appear. A bench warrant will be issued.
Yes, Your Honor.
Any additional matters?
No, I just want to make sure my notes were correct. He did not appear to get his GPS tether either.
I believe he is on GPS tether. I haven't gotten any indication that he did not receive his tether or that he's violated the tether, but he's not appeared in court today.
I believe that he has gotten his tether because the tether company contacted our office for addresses. So I believe that that's necessary when they actually come in and put it on. I'm not sure whether or not they do that beforehand, but that has happened. Otherwise, I don't have any other information regarding defendant's presence or his GPS tether.
Yeah, he was arraigned over the weekend, so he would have gotten that GPS tether before he was released from custody. So it looks like he does have it, but he just did not appear in court today. If Mr. Johnson, you do get in contact with your client within the next a couple of days, you can let me know and I can quash the warrant.
Thank you very much, Your Honor.
Thank you. Any additional matters for today's record?
No, thank you.
Everybody have a good weekend.
Have a good one. On the record in the matter of the people of the state of Michigan versus Jacob Charles Simmons, file number 23-01623, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
And good afternoon, Your Honor. Jared Austin appearing on behalf of Mr. Simmons. He's appearing with us today via Zoom.
Okay, today's the date that was set for a probable cause conference. The matter is scheduled for preliminary examination next week, August 25th at 9 o'clock in the morning on count 1, home invasion, 2nd degree, and count 2, larceny of 1,000 or more, but less than 20,000. Are we continuing to exam?
At this time, Your Honor, I believe that answers the defense. However, I would just put on the record that the people have made an offer for the defendant to plea as charged to count 2. With that, and an agreement to restitution in this matter, and with that, people would dismiss count 1.
Counsel?
Thank you, Your Honor. That is correct. At this point, we would ask the matter continue on to the preliminary hearing as scheduled for next week. And I will have an additional opportunity to discuss that with Mr. Simmons and how we wish to proceed. But for now, I wish to remain on as scheduled.
Okay, and then the offer, is that going to remain open until the time of the exam?
It is.
Okay. That's noted here on the record, and then we'll see Mr. Simmons in person at the court August 25th at 9 a.m. Any additional matters for today's record?
Nothing from the people, Your Honor.
I have nothing additional on behalf of Mr. Simmons, Your Honor. Thank you.
Thank you. You're all set, sir.
All right. Thank you, Judge.
Thank you. Okay. On the record in the matter of the people of the state of Michigan versus Michael Devontae Wilder, file number 23-02464, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good afternoon, Your Honor. Attorney Derek Hess, also the Office of the Public Defender on behalf of Mr. Wilder. I'm appearing by Zoom from the courthouse. He's appearing by polyconference in the Ingham County Jail.
Okay, today was the date and the time set for probable cause conference. This matter is scheduled for preliminary examination August 25th at 9:30. There's people in the waiting room. Are we continuing to exam?
At this time, Your Honor, the people have not made an offer in this matter. With negotiations will continue up in circuit court. And I believe that it is the intention, I will let Mr. Etheridge speak to this more, but I believe it is the intention of the defendant to waive its preliminary examination at this time. And like I said, with negotiations to continue up in circuit court.
Mr. Etheridge?
That is accurate, Your Honor. I would just ask Mr. Brodowitz to make a note in his file that I do believe Mr. Wilder would be eligible for YTA with the consent of the prosecutor, and we'll be asking for that in circuit court.
Okay, so the parties are unconditionally waiving exam?
Yes, Your Honor. Yes, Your Honor.
Okay, Mr. Wilder?
Yes, Your Honor.
You understand that you have the right to have a preliminary examination in this matter here in the district court?
Yes, Your Honor.
You understand the purpose of the preliminary examination?
Yes, Your Honor.
Okay, so you have the right to have the prosecutor meet their burden of probable cause. They have to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. Are you willing to unconditionally waive your right to examination?
Yes, Your Honor.
Okay, anybody making any threats to you to get you to waive your exam?
No, Your Honor.
Okay, any promises being made to you if you waive your exam?
No, Your Honor.
They understand that this is an unconditional waiver and you can't come back later and decide that you changed your mind or you misunderstood, you want to have your examination. You understand that?
Yes, Your Honor.
Okay. I find your waiver to be made freely and voluntarily. The matter will be bound over to the circuit court for a date of August 30th. You do not need to appear in circuit court August 30th. That's the date they're gonna get the file from this court. Your next court date's gonna be a pretrial in the circuit court. You'll get notice of that date through the mail by way of your attorney, okay?
Yes, Your Honor.
Okay, bond was set at 2,000 personal recognizance. That will continue. Any additional matters, counsel?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor.
Okay, you're all set, Mr. Wilder. Thank you.
Thank you, Your Honor.
Boardroom, Lansing boardroom. They're in the waiting room.
CO.
On the record in the matter of the people of the state of Michigan versus Edward Foss. File number 23-0246-7FY. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good afternoon, Your Honor. John Abbott, representing Mr. Faust, who appears by video.
Okay, Mr. Foss, can you state something, please?
Yes, ma'am.
Okay. Can you remove the jail, please? You have to monitor the Zoom. I can't do it. But today's the date and the time set for a probable cause conference. The matter is scheduled for preliminary examination August 25th at 9:30. Are we continuing to exam?
I believe that is the plan, Your Honor. I would leave it to Mr. Abbott to say for certain. I would just like to put on the record that the people have made an offer in this matter for the defendant to plea to count 3 domestic violence with 76948 if eligible, and with that, people would dismiss counts 1, 2, and 4.
Okay, to plead guilty to count 3 with 769.4A, and what else?
And with that plea, the people would dismiss counts 1, 2, and 4.
Okay, very good. Mr. Abbott?
Your Honor, I've discussed this with Mr. Faust, and it's my expectation that he'll be accepting that offer. I'd like to set it on for a plea next Friday, and I'll get somebody from my office to cover that hearing.
Okay, so we'll continue to the exam date, but we'll expect that to be a plea?
That's correct, Your Honor.
Okay. Okay, so we'll see Mr. Foss next week. If we're not running an exam, Mr. Foss, you can't appear via Zoom, okay?
Okay.
Okay. Do you have any questions?
No, ma'am.
Okay, bond was set at 2,000 personal recognizance. There's a no contact order for Laura and Damian Cassidy. That will continue. Any additional matters for the record today?
Nothing from the people, Your Honor.
Nothing from the defense. Thank you.
Okay, you're all set, Mr. Foss. Thank you. On the record in the matter of the people of the state of Michigan versus Christopher Galloway, file number 22-03066, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Attorney Derek Etchison, Office of Public Defender, on behalf of Mr. Galloway. I'm appearing by Zoom. He's appearing by Zoom as well, Your Honor.
Thank you. Today is the date and the time that's scheduled for probable cause conference. The matter is scheduled to continue to exam on August 25th at 9 o'clock in the morning in person at the court. Are we continuing to exam?
For that, Your Honor, I would leave it to Mr. Etheridge, as he spoke with his client. However, I would put on the record that the people have made an offer in this matter for the defendant to plea to, I believe, it'd be an added count 4 of aggravated domestic violence with DV court and restitution in this matter, Your Honor.
Has he been screened for DV court?
Not at this point, Your Honor. I would need to know if he plans to accept that deal before we have him screened for DV court.
Your Honor, also part of the deal would be that dismiss counts 1, 2, and 3. Your Honor, I have discussed this with Mr. Galloway. At this time, he is considering it, but it has not accepted it, and he would ask the court leave the matter on for preliminary examination next week.
Okay, so we'll continue to examine. Is this offer remaining open until the time of exam?
Yes, Your Honor.
Okay, so that'll be noted here on the file. We'll see Mr. Galloway in person at the court on August 25th at 9 a.m. Mr. Galloway, do you have any questions?
No, I have no questions, Your Honor.
Okay, very good. Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor. Thank you.
Bond set at 25,000. Personal recognizance with the no contact order protecting Bianca Green will continue. And we'll see you next week, Mr. Galloway.
Thank you, Your Honor.
You're welcome. We don't have anybody from the jail on right now, do we? Trevor King is in the breakout. Yes. Okay, very good. On the record in the matter of the people of the state of Michigan versus Kathleen K. Burden, file number 23-02209, counsel appearance.
Good afternoon, LaDonna Logan on behalf of the people. Anna, can you hear me?
I can. I was waiting to see if there was an attorney that was, defense attorney that was going to put
Okay, thank you.
his appearance on the record. Do we see his defense counsel here?
I thought I saw him.
I know we have an appearance. Do we see her? Is she here? Is there what?
I don't think so.
Is Kathleen Bearden here? That's unfortunate. I don't think she's appeared in court. I don't see her attorney either. Let's see. Militia bench warrant, bond forfeiture for failure to appear. Off the record on that one. On the record in the matter of the people of the state of Michigan versus Amy Marie Fascinello, file number 23-02211, counsel appearance.
Good afternoon, LaDonna Logan on behalf of the people.
Apologies, Your Honor.
Okay, counsel.
My apologies, Your Honor. This is George Danini appearing with Miss Kathy Burden. We were on mute and the video wasn't working, but we are here and present.
Okay.
Okay, well, we're now on the record of Fascinello, so we'll do yours in just a moment. Is counsel for Fascinello present? Ms. Fascinello, do you have an attorney?
Yes, I do.
Maybe they're a little bit late because they were scheduled at 2:30. It's 2:31. Let's see who this is in the waiting room. Who's on the iPhone that just joined the virtual courtroom?
And Nico Parker.
Okay. Can you rename her, please? Okay, off the record. Where's that file? Back on the record in the matter of the people of the state of Michigan versus Kathleen Bearden, counsel appearance.
Good afternoon, LaDonna Logan on behalf of the people.
Good afternoon, Your Honor. George Danini and Garrett Koger on behalf of Ms. Burden, who is with us in our conference room.
Okay, very good. Today's the date and the time set for probable cause conference. This matter is scheduled currently for a preliminary examination August 25th at 1:30 in the morning. I'm sorry, 1:30 in the afternoon. And then we also had a request to modify a bond restriction to allow the defendant to travel. We'll address that in just a moment. Are we continuing to exam? And I'm assuming we need to address the timeline if we are.
Yes, Your Honor. I've had conversations and really more email exchanges with Ms. Logan, and I believe that I want to speak to her.
I'm sorry, I can't hear you. There was some feedback. Can you repeat?
Yes, I've had communications with Ms. Logan, and I'll certainly let her speak for herself. I believe she's got another trial during that week of August 24th or 25th. So, and I believe there's also a later date scheduled for at least a couple of the defendants in this case on October 12th. So we're willing to move the exam date out to that date or a later date. And then if that is granted, then I think we can turn to the request to modify bond conditions.
Okay, so we do have some that have been scheduled to October 12th. One is, I think, November 2nd. And another one's gonna have a probable cause conference again in December. But nonetheless, Ms. Bearden has the right to have her exam within 21 days of her arraignment. And Ms. Bearden, are you willing to waive the timeline?
Yes, I am,
due to
Your Honor.
your conflict? Okay, anybody threatening you to get you to waive that timeline?
Oh, not at all.
Okay. Okay, we'll reset this to the October date at this time.
October 12th at 8:30.
October 12th at 8:30. That'll be in person at the court if that's the date we run the exam, okay?
Thank you.
No problem. Then lastly, there was a motion to modify the bond restriction so that the defendant can travel to a pre-planned event. It says August 20th to August 26th. The only issue I had is it didn't tell me where she was going or where she would like to go.
Yes, Your Honor, my apologies. I did speak with the court's clerk that provided that information. The travel is to Milwaukee, Wisconsin, and it's in connection with an RNC conference where she has roles to play during that 5-day period or 6-day period.
Okay, was that for the Republican National Convention?
That's correct, Your Honor.
Okay, the request to travel is approved for those dates and times for that purpose.
Thank you, Your Honor.
Okay, and then all of the bond conditions will continue and bond as said at 1,000 personal recognizance. Any additional matters for the record today?
None for the people, thank you.
None for the defense, Your Honor. Thank you.
Thank you, you're all set.
Thank you, Your Honor.
You're welcome. I don't know who's on the telephone there. They're gonna have to wait to see logged in the telephone. Yeah, Trevor King said he was that. Trying to figure out who's. Are we ready with Trevor King?
Yes.
Okay. On the record in the matter of the people of the state of Michigan versus Trevor Anthony King, file number 23-02465, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
An assistant public defender, Sarah Donnelly, on behalf of the defendant, Trevor King, who is appearing separately from Lingham County Jail.
Okay, Mr. King, today is the date set for your probable cause conference on this matter with 1 count of police officer assault, resisting, obstructing, and count 2 of malicious destruction of personal property less than 200. The matter is scheduled for an exam. That's on August 25th at 9:30. Counsel, are we continuing to the exam?
I believe at this time, Your Honor, yes, the parties will be proceeding to exam on this matter. However, in discussions with the defense counsel, I believe there may be the potential for a referral for either competency or criminal responsibility. I would leave it to Ms. Donnelly to clarify that. And I would just like to put on the record that people have made an offer in this case that if the defendant were to plea as charged in the corresponding misdemeanor file that is before Your Honor on scheduled for this Monday, which is file 23-01578-SM. If he were to plea as charged to the aggravated assault and agree to restitution on this file, then the people would dismiss this file.
Okay, the offer was for him to plead to the ag assault on the other and pay restitution on this file?
Yes.
Okay, just for the record, he would need to pay the restitution at the time that he plead. We can't order restitution on this file and another file.
Okay,
Okay,
yep. And with that, the people would then move to this, like I said, dismiss this case in its entirety.
okay, sounds good. So what we'll do is note that on this record. And counsel, how do you want to proceed?
Your Honor, I do agree with Mr. Brodowitz to leave this on for preliminary exam. It might also wanted to look for the option of screening for mental health court I know that usually the 55th District Court wants to make sure that Your Honor, does not have any objections to that. So in that case, if I would be also looking for possibly an offer that included mental health court.
Okay, I don't have any objection to that. I saw even at the time of the arraignment, I think there was a concern about some mental health services. So I think a screening for mental health court would be appropriate.
All right, thank you, Your Honor.
Okay, so do we want to still continue to the August 25th date now, or do you want to have it set out so it can be screened?
Your Honor, I just leave the date on for next week. We can address the timeline at that point if we so choose.
Okay, sounds good. So we'll continue to next week at this time, and bond set at 5,000 cash surety will also continue. Any additional matter on today's record?
Nothing from the people, Your Honor.
Your Honor, I would actually want to make a bond request. Mr. King has been in custody for 13 days now. He has a 5,000 cash surety on this file and a 10% 7,500 bond on the other file. He is unable to post it, and so we wanted to see if they can be converted to a PR. He has no problems being put on a GPS tether.
The disorderly jostling, isn't that before me?
There's the, you mean the other misdemeanor file?
Yeah, there was a disorderly jostling misdemeanor 2019. I think that was before me. Was that the one that we set out for him to do community service?
That was a loud and boisterous on a city case, and
okay, I see that as well, a misdemeanor from 2023. But I'm just trying to make sure I have the right. Is this the right defendant I'm thinking of?
It might not be. I only have these 3 cases, so the 2 open active, like Mr. Brodowitz said, the aggravated assault.
Failed to appear. Yeah, I'm the right guy. He failed to appear multiple times. That's why he doesn't have a PR bond. He doesn't come to court.
Your Honor, he does report that he lives with his mother, and like I said, he would have no problems with a tether. I believe that he would be able to be tracked with that.
It's nice that we can track you. We don't want to have to track you down when you don't come to court. We want you to just come to court if we release you on your own recognizance. The purpose of that is that we don't have to come track you down to come to court.
Yeah, say something.
You absolutely can. I'm going to advise you of the right to remain silent, though anything you say can be used against you, but you can say what you need to say, sir.
I understand your concerns, but with me not showing up to court, I can just say that the reason I was missing court before is because I was working 3 jobs trying to support the mother of my child, and I was getting alarms confused with my like doctor's appointments alarms and stuff like that. But since I've been released in May, I lost all 3 of my jobs, and I've been spiraling downwards ever since. I'm trying to just get back up on my feet, and I promise that I will not miss a court date, and I will agree to the tether bond as well, and any other anger management programs or anything like that you might provide or whatever.
Okay, this is not a situation where you've been charged with assaulting a person from the public or anything of that nature. This is a allegation of damage to personal property, and then a police officer resisting and obstructing. I think prior to this, all of the things that you've been before the court for have been along the lines of disorderly, loud and boisterous, again, disorderly. Not serious matters then, but it does appear that these matters are escalating, and that you would benefit from getting screened and having an opportunity to address any issues through mental health court if eligible. But we can't do that if you don't participate, sir. If we have to keep tracking you down and resetting things, and you don't appear when you're supposed to appear to be screened, we can't get you the help that you need. You understand that?
Yes, ma'am. I'm also currently enrolled with community mental health right now, and I got a caseworker assigned, and I planned on attending AA meetings as well as therapy as well.
Okay. What address do you think that you can reside at if you're released?
My mom's address, I don't know the address off the top of my head, but she just recently moved, so it's over in Mar Apartments off of Pennsylvania and Kavanaugh. Those apartments right there.
Okay, bond will be amended to 5,000 personal recognizance with GPS tether. While on bond, you have the following conditions. These are the same conditions essentially that you had at the time of your arraignment. You're not to travel outside the state without prior approval of the court. You're not to use, purchase, or possess drugs or alcohol without a valid prescription. You're not to possess a firearm, ammunition, or any other dangerous weapon. I am going to order that you participate in weekly urinalysis testing, which is not a condition that was previously ordered. And then you need to have GPS tether. You need to appear for all of your court dates. We're not going to track you down. Do you understand that?
Yes, ma'am.
So you've ran out of chances to miss court. If you miss court just once on this, even if you're late, you're going to be remanded and you'll be sitting in jail until this matter is resolved. Do you understand that?
Yes, ma'am.
Okay. Do you have any questions about your bond conditions?
Is this being converted into a personal recognizance bond, or do I still have to post the 10%?
Nope, it's being converted to a personal recognizance bond.
All right, thank you, Your Honor.
You're welcome. Any additional matters for the record, counsel?
Nothing from me, Your Honor.
And nothing for defense. Thank you, Your Honor.
Thank you. You're all set, Mr. King.
Thank you, Your Honor. Have a good day.
You're welcome. Back on the record in the matter of the people of the state of Michigan versus Amy Marie Fascinello. I did have the Attorney General's appearance. I don't see counsel. Did counsel join us for Ms. Fascinello? Do we know who's on the phone here? Who's on the phone number ending in 8441?
Yes, good afternoon, Your Honor. Paul Stablin. I am the attorney for Ms. Fascinello. And unfortunately,
Okay.
I'm in a building, didn't have any internet, and I had to call in. I apologize.
Okay, sounds good. I'm going to give you a pass just because I've already given the Assistant Attorney General a pass. I don't know if anyone told you all, I do not do appearances without video because you can come in person. So I'm going to give you a pass today. Just because the AAG doesn't have the ability to have video either, okay?
Appreciate it much.
Okay. Today's the
I
date
won't
and
let it
time
happen
set for,
again.
no problem. Today's the date and time set for probable cause conference. The matter is scheduled for preliminary examination August 24th at 1:30. And I'm assuming we need to address the timeline?
Yes, Judge, I just did receive discovery not that long ago from the Attorney General, and I am asking the court that we be given some time to prepare. I know that other defendants have been set in October. I don't know if that is okay with the court, but there is a large volume of discovery that was provided by the Attorney General. And
yes, we have some that's set for November as well. If the October date doesn't work for you, I think October is October 12th and November is November 2nd. Does either one of those appeal to you more than the other?
October is fine with me, Judge.
Okay.
I've looked at that date already. If it's October, if we're talking about October 12th.
That's correct.
Okay.
Okay. Ms. Fascinello, you have the right to have your preliminary examination within 21 days of the date of your arraignment. Are you willing to waive the timeline so this matter can be reset to October 12th, which will give you and your attorney time to review discovery to formulate your defense?
Yes, I am, Your Honor.
Okay, is anybody promising you anything or threatening you to get you to waive the timeline?
No.
Okay, we'll reset this matter to October 12th. Was it at 10? At 8:30 in the morning. That's in person at the court, okay?
Okay.
Thank you, Your Honor.
Thank you.
No
Thank you, Your Honor.
No problem. Bond will continue. Any additional matters?
No,
None
Your
for the
Honor, we're all
people.
set.
Thank you. You're all set, Ms. Fascinello.
Thank you.
You're welcome.
Thank you, Your Honor.
On the record, thank you. On the record in the matter of the people of the state of Michigan versus Clifford James Frost, file number 23-02212, counsel appearance.
Good afternoon, LaDonna Logan on behalf of the people.
And good afternoon, Your Honor. Kevin Kiefsky, P74-153, appearing on behalf of the defendant, Mr. Clifford Frost, who's immediately to my right. Sir, can you please state your name fully and loudly for the record?
Clifford J. Frost.
Thank you. Today's the date and the time that's scheduled for probable cause conference. The matter is also scheduled for preliminary examination August 25th at 1:30. And I believe this needs to be adjourned as well. And there's also a motion that was filed by the defense for a separate probable cause conference and preliminary examination. I think that the motion for separate probable cause conference is mute because this is separate. But as it relates to the exam, I don't have a response from the AG. Did the Attorney General intend to file a response to that motion?
Well, Your Honor, I received the motion while I was out of state, so I didn't have the time to prepare a written response. If the court would allow me
just
time, I
received it,
could.
so I will absolutely grant you time to respond because we didn't get it until a couple of days ago.
I would like to respond in writing then, Your Honor.
Okay.
Your
very
Honor,
good.
if I may, ever so briefly, perhaps this could become a moot point. We did file it Friday before the close of business. We sent it as well electronically to the Attorney General's office. But perhaps if we're able to find a date for a preliminary examination that would be separate and distinct, I would be happy to withdraw the motion, thereby making it moot, but I don't know what the court's preference would be.
Okay, well, I think it's important to allow the Attorney General to make their response before we decide that issue. What I can do, because I'm sure that you still have discovery that you're reviewing. I can treat next week as another probable cause conference and a hearing date for that motion if that works for both parties.
Your Honor, I'm scheduled to be in a homicide trial next week. And although I think it won't take long, I'm pretty sure I will still be in trial or at least waiting for doing closings on the 25th.
Okay, sounds good. So, Mr.
Your Honor, if I may quickly reply, I have no problem with sister counsel wanting to push it a little bit later. I have spoken with my client. He would be willing to waive the 21-day rule. I can also voir dire him to that effect in order to satisfy the court's requirement that this is being done freely and voluntarily. I would like to ask, if possible, we can maybe set this for another PCC, maybe in 2 or 3 weeks. I think that would give the people enough time. And also we can maybe have the matter perhaps settled even before that time of the next PCC regarding the motion.
Okay, can you voir dire your client, please?
Absolutely. Mr. Frost, do you understand that from the date of arraignment, you have a statutory right to have a preliminary examination within 21 days?
Yes, I do.
You understand that through my actions today, I am asking you to waive that, and you have agreed to do so, correct?
Yes, I do. Yes, I am.
And you are doing so freely, voluntarily, and more so through your own volition without any type of promises, inducements, or threats.
Absolutely.
And you understand that if you agree to this, this is not something that you're going to be able to kind of appeal or take back at a later time. You understand that?
Sure do.
Your Honor, is the court satisfied?
I am. I will reset this matter for another probable cause conference and a motion for the separation of the preliminary examination. September 7th at 8:30. September 7th at 8:30 work for both parties?
Yes, Your Honor.
Yes, Your Honor.
Okay, that'll be the date and time that we proceed for a hearing and another probable cause conference, and then we can address the date of the preliminary examination at that time. Any additional matters on this record?
None for the people. Thank you.
And nothing from the defense, Your Honor. Thank you very much for your time.
Thank you. Bond will continue, and we'll see you on September 7th.
Thank you.
Thank you. On the record in the matter of the people of the state of Michigan versus Stanley Grott, file number 23-02213, counsel appearance.
Good afternoon, LaDonna Logan on behalf of the people.
Good afternoon, Your Honor. Derek Wilchinski on behalf of the defendant, Stanley Grote.
Okay, Mr. Grote, today's the date and the time that's set for probable cause conference. Your matter is scheduled for preliminary examination August 25th at 1:30. I'm sorry, August 24th at 1:30. I'm assuming we need to address this timeline as well, counsel.
That is correct, Judge. We appreciate it. I think the November 2nd date would work just fine.
Okay, and Mr. Grote, you understand that your right to have a preliminary examination within 21 days of your arraignment?
Yes, I do, Your Honor.
And you're willing to waive that right so that we can reset this to a new time outside of that 21 days?
Yes, Your Honor.
Has anybody threatened you or made any promises to you to get you to waive the timeline?
No, Your Honor.
November 2nd at 10 a.m.
November 2nd at 10 a.m.
Thank you, Your Honor.
Thank you, Judge.
Thank you, Bond. Will continue. Any additional matters for today?
There is, Judge, just one minor matter. Mr. Grote was trying to arrange to have his fingerprints taken. I'm asking the court that he be allowed to do it at the Macomb County Sheriff's Department, so he does not have to drive up to Lansing in order to do it. He's a resident of Shelby Township, Michigan, and this would save gas, time, wear and tear on his car, wear and tear on Michigan roads, and we would respectfully ask that he be allowed to do it in Macomb County at the Sheriff's Department.
No, he has to do it here.
Very good, Judge. We will make arrangements. Thank you.
Thank you.
Have a
Any
great
additional
day.
matters?
No,
You
there
too.
are none, Judge.
Thank you.
Thank you.
On the record in the matter of the people of the state of Michigan versus John Earl Haggard, file number 23-02214, counsel appearance.
Good afternoon, LaDonna Logan on behalf of the people.
Good afternoon, Your Honor. Takura Nyamfukuza on behalf of Mr. Haggard. I'm appearing by video, as is Mr. Haggard.
Mr. Haggard, okay, I see him present. Today's the date and the time set for probable cause conference. This matter is scheduled for preliminary examination August 24th at 1:30. Are we continuing to examination and do we need to address the timeline?
Yes to both, Your Honor.
Okay, and Mr. Nanfukuza, did you discuss the timeline with your client, and is he willing to waive the 21 days?
He is, Your Honor. We've discussed it multiple times, and I'm happy to ask him questions to that effect.
Please do.
Mr. Haggard, would you please unmute? Mr. Haggard, would you please unmute so the court can hear your responses to my questions?
I wonder if he can hear us. Can you hear us, Mr. Haggard?
Mr. Haggard,
can you hear us? I'm inclined to believe that he can't hear us. He only moved because I sent a virtual request for him to unmute.
Okay. Let me, gee whiz. May I?
We can go off the record and you can give him a phone call.
Yes, thank you.
Thank you. On the record in the matter of the people of the state of Michigan versus Timothy Allen King, file number 23-02216, appearance, please.
Good afternoon, Your Honor. Michael Vincent on behalf of Timothy King, who's present in my conference room. Mr. King, say good afternoon and state your name for the court.
Good afternoon, Your Honor. Timothy Allen King.
And LaDonna Logan on behalf of the people.
Thank you. Today is the date set for probable cause conference. The matter is scheduled to proceed to an examination on August 24th at 1:30 in person at the court. Are we continuing to exam, and do we need to address the timeline?
Yes, we're going to need I have a stack of papers. I think you can see them on the screen that we received from the Attorney General. And I'm going to have to spend a considerable amount of time going through that. So an October or November date would be fine. My client and I have talked. Mr. King, are you prepared to waive your 21-day right to have a preliminary examination?
Yes.
And no one's threatened you or in any manner forced you into doing this?
No.
And this is your choice to do this?
Yes.
Thank you.
Thank you. Okay, so I'll find the waiver of the 21 days to be made freely and voluntarily. We'll reset this matter. Did you have a preference for the October 12th date or the November 2nd date?
My assistant here tells me we're good for both. So either which the court pleases.
More of October already. Or 1 October. November. 3 November. Okay. November 2nd at what time? At 10 a.m. in person at the court.
Thank you.
Thank you.
No problem. Bond set at 1,000 personal recognizance will continue. Any additional matters for today's record?
None for the people.
None, Your Honor.
Okay, you're all set for today,
Thank you.
Mr. Thank you. Mr. Namfukuza, did you get Mr. Haggard's audio situation squared away?
Your Honor, I am going to try to improvise. I have him on the phone, and I hope there won't be too much feedback while he is addressing the court on speaker. Mr. Haggard,
Shouldn't be, because he's muted.
Oh, he was having difficulty with the buttons on
No, I'm
the
saying there shouldn't
application.
be there should not be feedback because we muted his device here, so it should be
brilliant.
fine.
Brilliant. Mr. Haggard, can you hear me and the court?
I can hear you, yes.
Is he audible to the court, Your Honor?
He is.
Okay, Mr. Haggard, before we went off the record a few minutes ago, we were discussing your right to preliminary examination. Both Mr. Kraus and I have talked to you about that examination. You understand what it is?
Do what now? Do what now?
Oh, please, I've muted the phone. Can you hear me now?
Are you there?
We don't want feedback, so let's only use one device.
Okay. Hold on. Am I on the speaker on the television now or the computer?
Can't
hear anybody. Can't hear anybody on your side.
Boy. Mr. Haggard, can you hear me? Mr. Haggard, can you hear me?
Yes, I can. Yes, I can.
Okay, could you mute one of your, either hang up the phone or mute your computer, because now we haven't seen that.
The computer is muted.
Okay, I'm going to hang up the
I'm gonna
phone.
mute him.
Okay.
I just muted him.
Okay, very good. Can you still hear me, Mr. Haggard?
Yes.
Okay, Mr. Kraus and I have talked to you about a preliminary examination, and that is when the government would have to establish that a felony was committed and that you are the person who committed it, and the standard of proof is probable cause. Do you recall those discussions?
Yes, I do.
And do you recall both myself and Mr. Kraus explaining that you have the right to have that examination within 21 days?
Yes, I do.
And you understand and agree that because of the volume of discovery that both our firm and you would have to review in formulating a defense on your behalf, that it would behoove you to have that preliminary examination outside of the 21-day period.
Yes.
And you are doing that not as a result of any threats or coercion, but of your own free will, following that discussion with both myself and Mr. Kraus.
Yes.
And would you like the court to schedule your preliminary examination for a date after the 24th of August?
Yes, please.
Your Honor, I hope that was a sufficient factual basis.
Okay, it is sufficient for me. We'll change the court date to find this waiver of the timeline to be freely and voluntarily made. Does the October 12th date or the November 2nd date appeal to you one way or the other?
The November one would be more preferable, Your Honor.
Okay, November 2nd.
November what?
Oh,
November 2nd at
the
10
2nd
a.m.
The 2nd of November at 10 a.m. Mr. Haggard.
Yes.
That's in person at the court. Bond set at 1,000 personal recognizance will continue. Any additional matters for today's record, counsel?
Yes, Your Honor. A standard condition of bond is that he not be allowed to possess firearms or travel outside of the state. And Mr. Haggard has been taking an annual trip to Sioux Falls, South Dakota, for many, many years for the purpose of hunting. So while we certainly are familiar with submitting written travel requests, I would ask that the court reconsider the firearm prohibition, and particularly for the purpose of the hunting, Your Honor. We would submit all the confirmation of travel and so on, but of course, even if he can travel, if he cannot handle a firearm, then that would defeat the purpose of the trip in the first place.
Okay. He's not made a request for this. This is your anticipation of the request. Is that what you're asking?
Correct. Yes, Your Honor.
Okay, that's, I didn't see a request for travel here. If he files an appropriate request for the purposes of going on a hunting trip in North Dakota, the court will review that at that time. I don't have a issue with granting leniency as it relates to that trip, but outside of that, the other bond conditions will still continue as set.
Very good.
That's South Dakota, Your Honor.
I'm sorry?
Oh, he was saying it's South Dakota, and I
okay, South
think
Dakota.
this
Okay,
reiterates-
sounds good.
Yes, Sioux Falls, yes.
Okay, sounds good. Once we get the request, I can review it appropriately and approve. I don't know if the AG has any objection to it, but they'll file or notify the court of any objections at the time the request is made, okay?
Thank you, Your Honor. Thank you for your time.
No problem. You're all set for today, Mr. Haggard.
Thank you.
Your Honor, I don't know if you heard that was South Dakota.
Yes, yes, Mr. Haggard, the court is aware.
I heard, Mr. Haggard.
Okay, thank you. Thank you for your time, Your Honor.
Thank you.
All right.
You're all set, Mr. Haggard.
Thank you.
On the record in the matter of the people of the state of Michigan versus Michelle Lundgren, file number 23-02217. Council appearance.
Good afternoon, LaDonna Logan on behalf of the people.
This is Michelle Lundgren. I'm not sure if my attorney's present. What am I doing?
Okay, let's see. It's Mr. Silverthorne, isn't it?
Yes.
Yes.
I will start over. Good afternoon, Your Honor. Dwayne Silverthorne from the Office of Public Defender on behalf of Michelle Lundgren. I'm appearing by Zoom, as is Mrs. Lundgren.
Okay, very good. So Ms. Lundgren, today is the date set for a probable cause conference. Your matter is scheduled along with about 15 other co-defendants for a preliminary examination. Yours is currently scheduled for August 24th at 1:30. Mr. Silverthorne, are we continuing to examine and do we need to address the timeline?
We do need to address the timeline, and I can do that with Ms. Lundgren if you'd like, Your Honor.
Yes, please.
Yes, Ms. Lundgren, you realize that from the time that you're arraigned, you have the right to have a preliminary examination held within 21 days. Is that correct?
Yes,
Okay, and we spoke several days ago about me needing additional time due to the volume of discovery to extend that out. Is that correct?
yes,
You are agreeing that you will waive that timeline. Is that correct?
yes,
You understand that you're not waiving the right to have the exam itself, just that it can be put off to a later date. Is that correct?
yes.
And was there any coercion or threats made to get you to do this?
No,
You're doing it freely and voluntarily?
yes.
Thank you, Your Honor.
Thank you. I'll find your waiver to be freely and voluntarily made, and we'll set this matter for a new court date. Mr. Silverthorne, we have an October 12th date so far, and we have a November 2nd date. Does either of those work for you?
Either of them work. I will fit whichever one fits better with Your Honor's schedule.
We'll reset this to October 12th. That was at 8:30. Yeah, at 8:30 in the morning in person at the court. Bond in this matter set at 1,000. Personal recognizance will continue. Any additional matters for today's record?
None for the people. Thank you.
Nothing for the defense. Thank you, Your Honor.
Okay, you're all set for today, Ms. Lundgren.
Thank you very much.
You're welcome.
Bye.
Thank you, Mr. Silverthorne. On the record in the matter of the people of the state of Michigan versus Shaniqua Parker, the file number is 23-02121, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Ms. Parker, can you hear me?
Yes, I can hear you.
Okay, Ms. Parker, today was the date that we reset your probable cause conference because you've told us now 1, 2, 3 times that you were retaining Mr. White.
Correct.
What's
sorry.
happening?
It was hard getting a hold of him, but I was in touch with Kendall and I've been talking with him. I was supposed to meet him with payment today, or her, I don't know. Kendall at 4:30, and then to discuss the case on Monday. So I do want to move forward to the next step. I'm sorry, I lost my voice.
Okay, the matter is going to be set for a preliminary examination. I need you to appear in person.
Okay.
Let me get you a date.
You want to sit out so she can take it. I just want to make sure she can take it so you can just get an next date. No, let me know. I can do it for
August 25th in person at the court at 8:30, okay?
August 25th, okay.
Do you have any questions at this time?
Nope.
Bond said at 1,000 personal recognizance will continue. Any additional matters, counsel?
And nothing from the people, Your Honor.
Okay, Ms. Parker. Oh, who's this? Is that Jamie White? Okay, you're all set, ma'am.
Thank you so much.
You're welcome.
Your Honor, Michael Bellata for Miss Rose Rook. Can I request that you call our case because I'm about to walk into federal court. I have to be there in 15 minutes, and I've been on this Zoom for a long time now.
Yeah, I've been on the Zoom for a long time too, actually. There's a lot of cases.
I understand, but I was set for 1 o'clock, and then I was told that it wasn't 1 o'clock, it was 2:30. So I've been waiting since 1 o'clock. But
Yeah, you're actually set for 2:30. You were not set at 1 o'clock.
well, the paperwork I have says 1 o'clock. So
Which matter is Mr. White here on? Who? Which person? No, this is Jamie White, not Toby White. Oh, okay. Jay White? I thought we took care of Victor's case. Who's identified as Jay White? Okay, I'm gonna put him in the waiting room, so I don't know who that is. On the record, in the matter of the people of the state of Michigan versus Rose Rook, file number is 23-02221 FY, council appearance.
Good afternoon, LaDonna Logan on behalf of the people.
Good afternoon, Your Honor. Michael Bellata on behalf of Rose Rook, who is present on the Zoom and waives her 21-day time frame for the preliminary examination.
Okay, Ms. Rook, today's the date that was set for a probable cause conference. Your exam is currently scheduled for August 24th at 1:30, but your attorney is indicating that you want to waive the 21-day timeline. Can you unmute and advise if you understand your right to have that exam within 21 days?
Yes,
Okay, and are you willing to waive the timeline, ma'am?
yes, Your Honor.
Is anybody threatening you or promising you anything to get you to waive the timeline?
No, Your Honor.
Okay, Mr. Or counsel, which date appeals to you? We do have an October 12th date, and then we also have a November 2nd date.
November 2nd is better for me, Your Honor.
Okay, November 2nd at 10:30 a.m. in person at the court. I'm sorry, 10 o'clock a.m. in person at the court will be the new date for your preliminary examination, okay?
Thank you.
Thank
No
you.
problem. No problem. Bond set at 1,000 personal recognizance will continue. Any additional matters for the record?
No, thank you, Your Honor.
No, Your Honor.
Thank you.
Thank you
You're
for
all
calling the
set.
case. Appreciate it.
No
Thank you.
problem. You're welcome. I'm looking at this paperwork. He's right. This does say in the file 1:30, but it's not on my docket for 1:30. We didn't do it. Let's see. On the record, in the matter of the people of the state of Michigan versus James Robbins Renner, file number 23-02219, council appearance.
Good
Good
afternoon, LaDonna Logan on behalf of the people.
Good afternoon, Attorney Matt Bargula, on behalf of Mr. Renner, who is seated with me to my left.
Okay, Mr. Renner, today's the date set for your probable cause conference, and you're scheduled for an exam August 24th at 1:30. Council, are we addressing the timeline today?
Yes, we are, Your Honor. We asked that we have a preliminary exam on the November 2nd date. Mr. Renner waives his right to the 21-day rule and is prepared to proceed at the later date, Your Honor.
Is that correct, Mr. Renner?
That is correct, Judge.
Okay, and you understand that you did have the right to have it within 21 days, and no one is threatening you or promising you anything to get you to go beyond that 21-day timeline?
That's correct, Judge.
Okay. Mr. Borgula, did you have a particular date that you preferred?
Yes, Your Honor. We prefer the November 2nd date.
Okay, we'll reset this matter for November 2nd at 10 a.m.
Thank you, Your Honor.
Thank you.
That's in person at the court. No problem. Bond set at 1,000 personal recognizance will also continue. Any additional matters?
None for the people.
None for the defense, Your Honor. Thank you.
Thank you. You're all set for today. On the record, in the matter of the people of the state of Michigan versus, is it Myra Rodriguez, file number 23-02220, council appearance.
Good afternoon, Your
afternoon.
Honor. I'm sorry, go ahead, Ms. Logan.
Thank you, Mr. Blake. Good afternoon, LaDonna Logan on behalf of the people.
Good afternoon, Your Honor. Wright Blake appearing on behalf of Maida Rodriguez, who's
Thank you.
present.
Today's the date. I do see she's present via Zoom. Today is the date that's set for probable cause conference. The exam is currently scheduled for August 24th at 1:30 p.m. Are we addressing the timeline?
Yes, Your Honor. We don't have discovery yet. We would ask the court to reset the probable cause conference to the November date.
Okay, that's actually an exam date, but I can get you another probable cause conference before then if you'd like.
If it's the exam date, Your Honor, my client is medically unavailable on Tuesdays and Thursdays. So that would definitely be a conflict in her schedule.
She's medically unavailable on Tuesdays and Thursdays?
Yes, Your Honor.
Why is that?
Well, I don't want to be on social media and the news, but it would be life-threatening for her to physically be there on that date. But any other days of the week, we're available, but we're just not available Tuesday and Thursday.
Let me see. All of those, we don't handle these any other days. Let's see here. We have November 2nd, which is a Thursday, and then we have October 12th, which is also a Thursday. We do our exams on particular days. So you're requesting a special day. You need to file a motion with the court indicating why she needs a special day.
Okay, Judge, well, I just said it was life-threatening, but we'll take the November.
I recognize that, but I need further understanding why it would not be life-threatening for her to come in here on a Wednesday, but she can come on a Thursday. So you can, I recognize you don't want to disclose that publicly and you shouldn't have to, but I need an understanding because I need to, we don't do exams on Wednesdays or Mondays. I have other dockets that are preset. So I need to have a better understanding so that I can properly configure my docket and know why I'm configuring it that way.
I appreciate that, Judge. I can go in the breakout room with you right now.
I can't go in the breakout room because I have a courtroom full of people.
I see.
And
Okay, Judge.
including the media.
All right, Judge, I see. So give us the November 2nd date, Judge.
Okay, and Ms. Rodriguez, you understand that you have the right to have a preliminary examination within 21 days of your arraignment.
Yes, I do. Thank you, Your Honor.
Thank you. And you're willing to waive your 21 days so that your attorney can properly receive discovery and prepare to formulate your defense?
That's correct, Your Honor. Thank you.
Okay, anybody making any threats or promises to you to get you to waive the timeline?
No, not at all.
Okay, we're gonna reset this to November 2nd at 10 o'clock in the morning. However, once I receive your correspondence, Mr. Blake, we can address that date as necessary, okay?
When you say correspondence, does the court want a motion or?
You don't need to do a formal motion. You can speak to the court off the record.
Okay, great. Thank you, Your Honor.
No problem. Thank you. Any additional matters for today's record?
No, only
Nothing
the
for the people.
request for discovery.
Ms. Logan?
Nothing for the people, Your Honor.
Okay, he did make a request for discovery, but that's for your office to address. I don't know if you heard that.
I did, and I will get discovery to Mr. Blake.
Okay, sounds good. I will continue and we're all set for today's record.
Thank you, Your Honor.
Thank you.
Thank you. Mr. Johnson is back. I'm not seeing his client though. Okay, and then I think I have one more. On the record in the matter of the people of the state of Michigan versus Kenneth Thompson, file number is 23-02223, council appearance.
Good afternoon, Your Honor.
LaDonna.
I'm sorry.
Good afternoon, LaDonna Logan on behalf of the people.
Good afternoon, Your Honor. May it please the court, Attorney David Gilbert appearing on behalf of Mr. Kenneth Thompson. Mr. Kenneth Thompson also appears to be assumed from his home.
Thank you, Mr. Thompson. Today's the date that's set for your probable cause conference. Your matter is currently scheduled for preliminary examination August 24th at 1:30. Counsel, are we addressing the timeline?
No, ma'am, we're not. We're satisfied with August 24th.
Okay.
Actually, Your Honor, I'm actually unavailable on August 24th. I'm going to be in the homicide trial next week.
Okay, so you did mention that. Okay, so due to the prosecutor's conflict in scheduling, the court's gonna find good cause to go beyond the 21-day timeline. We'll reset this for October 12th at 8:30.
Thank you, Your Honor.
Thank you. A bond is set at 1,000 personal recognizance, and that will continue. Any additional matters for today's record?
None for the people, Your Honor.
Nothing from defense.
Thank you. You're all set for today, Mr. Thompson.
Thank you, Your Honor.
You're welcome. Okay, he's gonna, I guess, get Mr. Linton. Mr. Johnson? Thank you, Ms. Logan. I think that's all I have. For
That is, and thank
the
you very
election.
much for your indulgence, Your Honor.
No problem. Mr. Johnson,
Yes, Your Honor.
what brings you back so soon?
The court asked me to, the court staff asked me to log in, said my client had appeared.
Okay, is that Victor Nagbara?
Yes, Your Honor.
Okay, Mr. Nagbara, can you hear us?
Yes, I can hear you.
Okay, I can't see you though.
You can't.
Is something going on with your video?
It says that I have the camera on.
I recognize that, but I can't see you, which is a requirement for you to proceed in my trial. I mean, in my courtroom. I am, however, going to put you in a private meeting room with your attorney because I think he needs to get proper contact information with you, okay?
All right, thank you.
We need Mr. Linton, is that correct? Yes. Okay. Yes, please. Okay. Oh, there we go. On the record, in the matter of the people of the state of Michigan versus Victor Obina Nwagbara, file number is 23-02457, council appearance.
Good afternoon, Mayor. Please, this honorable court, Kareem Johnson on behalf of Mr. Wabara, who's present on Zoom as well.
Okay, how many of the prosecutors appearance?
Okay, I guess I will. I'm not sure what Ms. Paula wants to do it. But I will stand in. Jeff Brodowitz on behalf of the people, Your Honor, standing in for APA Sarah Paula.
Okay, so today was the date set for probable cause conference. I think Mr. Johnson, I can't remember if you stated that you did not have discovery or you had just received discovery.
At this time, I do not have discovery, Your Honor. My office has been in contact with the prosecutor's office trying to get it.
Okay. Give me just a moment. Let's see here. Mr. Brodowitz, can you get a message to whoever needs the message so that we can make sure Mr. Johnson gets discovery? We have an appearance. Your office has one?
I can check very quickly. Just one second.
And Your Honor, we do have time. It's my understanding that the co-defendant retained Rico Neal and the exam has been set out sometime.
I recognize that, but usually if there's issues of discovery, I set it for another probable cause conference. I like to avoid that if we can ensure that they have your appearance and they can just get that over. And then I could set this to the co-defendant's date. I am going to find good cause to go beyond the 21-day timeline. A, because we have a co-defendant case, and B, because you don't have discovery at this time. You said the co-defendant was what?
September 29th at 10.
September 29th at 10 o'clock is going to be the date for the examination. And then Mr. Brodowitz is checking to make sure that his office has received your appearance, Mr. Johnson.
At this time, Your Honor, after looking at our file, I do not believe we have received Mr. Johnson's appearance yet. However, I will relay that to APA Polga as well.
Okay, I signed the substitution today, I believe, so maybe that is why. We'll get or make sure that an appearance is filed by Mr. Johnson to the prosecutor's office. They do say they don't have it. And as to the bench warrant, I'll quash that warrant. I don't believe it's going to be necessary. He's going to make sure. Mr. Johnson, can you just ensure that you did file your appearance with the prosecutor's office because they don't have it?
Yes, Your Honor.
Okay, any additional matters for the record at this time?
No, Your Honor.
Okay, you're all set. Thank you.
Everybody have a good weekend.
Same to you. Okay, I don't have, I don't have this. The people of the state of Michigan versus Jason Linton, file number 23-02146FY. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good afternoon, Your Honor. John Abbott, representing Mr. Linton. He's standing to my right.
Okay, Mr. Linton, how are you?
Good, Your Honor, how are you?
I'm doing well, thank you. Today was the date that was set for a probable cause conference. The matter is scheduled for preliminary examination August 25th at 8:30. How are we proceeding?
Yes, Your Honor. At this time, I believe the parties would ask for an adjournment of the probable cause conference in this matter. There was a note in the file left by prosecuting attorney Aaron Housefield as to regards with some issues in this case. And I've spoken with Mr. Abbott about those issues, and I think those would be better. I know he's spoken with his client as well, but I believe those would be better addressed between Ms. Housefield and Mr. Abbott. So before, the people had no offer on this file either at this time, Your Honor. So in order to let Mr. Abbott and Ms. Housefield discuss those, I believe the parties would request a reset of the probable cause conference.
And of course, Mr. Abbott's not going to be available next week or the week after. So.
And, Your Honor, I didn't mean to interrupt, but I apologize.
No, you're fine.
So, he's currently under sentence in Eaton County for similar related problems. And it's my understanding that the judge there intends to send him to TRICAP on the 31st of August. Their policy there is you have to serve 90 days and then you can go to rehab. So his 90 days there probably already run, but he's scheduled to go to TRICAP at the end of the month.
Okay.
So they asked the court to modify his bond to allow him to go to TRICAP while Ms. Housefield and I sort out the case, and I expect it'll turn into a plea to abuse. Prior similar case.
Okay. So due to the issues being worked out between the prosecutor's offices and Mr. Abbott, in Ms. Housefield's absence, and to Mr. Abbott's unavailability for a couple of weeks, and then it looks like we'll need to get something set up while he's now at TRICAP. Gonna find good cause to go beyond the 21-day timeline and reset this. Is it September 7th?
7 and 9 for the
September 7th at 9 a.m. will be the new probable cause conference. Exam date. September 15th at 9:30. Exam will be set at September 15th at 9:30. Any additional matters for the record today?
Your Honor, he's currently held here. I'm not sure what his bond is.
It's 5,000. 10%, but I just admitted it's personal recognizance. You can go to TRICAP.
Thank you. Thank you.
Thank you. You're all set.